Farese trustee versus Sperounes.
Give me a card for the last case.
Thank you.
Good morning, Mr. Altman.
Good morning. May it please the Court. My name is Michael Altman, and I represent the petitioner in this matter, a 211-3 proceeding. From 1996 through 2004, the law governing the monetary limits of the district courts of the Commonwealth was $25,000, and the statutory scheme, at least in 11 of the 14 counties, defined the $25,000 as a jurisdictional limit. Having tried the one-trial system for a period of 8 years, the legislature in 2004 decided to expand the system statewide, and so it enacted a new statewide statute. The main purpose was to make the system statewide. A second purpose in the statutory scheme was to deal with issues that had arisen because the $25,000 statutory amount was specifically jurisdictional under the old statutory scheme, and the legislature wanted to make it non-jurisdictional.
Hey,
So,
Mr. Altman, could I ask you a question? Could we solve this problem by just saying that we have to read the that 19A just governs how the court does it. It just spells out the procedure. So you have to read the may there to mean shall. Would that solve the whole problem, that the court can't exercise jurisdiction to retain cases over the $25,000? So the may in there was just the legislature really meant shall in 19A.
that would be one way to solve the problem. I think the may has meaning, however, for cases in which
Neither
the
party
defendant
objects.
chooses not to object to the requirement. The legislature changed the jurisdictional amount to the word requirement, says may only proceed, and the whole system here now requires that the defendant say, I don't want a trial in the district court. So the assumption here is there may be some cases in which the parties, for whatever reason, because the lawyers' offices are nearby, it involves something locally that the parties want to present to the court, so they want to stay in the district court. However, the district courts, as we know, are courts that are fairly high volume in most places. They need to churn through a lot of cases. So even if the lawyers want to keep the case there, if it's a 3-week case that's going to burn up a lot of time in the local court and involve
Well, I think it would still work if we read it as shall, because the judge, the may changing to shall dismiss the case without prejudice. That would only occur, if you read the statute, after receiving written responses from the parties and after a hearing, if the hearing is requested by any party. Yeah. All right. Strike that. I'm sorry. That won't solve it.
So our argument here is that the language may proceed only if the language in the statute, which is also amount necessary to proceed, the $25,000, the amount necessary or less to proceed, and also calling it a requirement, that those words have meaning in the statute. And basically what was involved here is that the Malden District Court, in this case, was proceeding in accordance with the directive of Chief Justice Conley, and her memorandum is part of the appendix. And in her memorandum, she says, dismissal is a matter of the court's discretion and appears to be immune from review. So the Chief Justice took the position that the district court may keep any case, no matter the amount in controversy, no matter its complexity, and
Of course, you could get a $10 case that's horrendously complex. The money doesn't necessarily determine the complexity of the case.
So that doesn't necessarily indicate the complexity of the case, except money does, in some ways, in a very rough way, define the complexity of a case. Because, I mean, if there's $20,000 in dispute as opposed to $2 million in dispute, the parties are usually much more willing to put the time and energy into discovery, into fighting about any issues along the way, as opposed to $20,000. So if it's a smaller amount, it tends to be a simpler case.
Explain to me why it was, you were about to, I think earlier, why the legislature decided that this $25,000 amount should no longer be jurisdictional. It would be a requirement but not jurisdictional. What was the problem that they were trying to fix?
Well, the problem, there were a whole range of issues, some of which are reported in appellate division cases. What happens if the plaintiff brings a case, it's for $26,000, it recovers $26,000 or $36,000, the statement of damages says $25,000, is that, and the court really determines that it should have been, it really should have known it was 35. Is that reversible because there's a lack of jurisdiction? If there's a jurisdictional problem, it's a subject matter jurisdiction problem, it means the defendant can sit back, and if the plaintiff forgot to put the right amount of damages on the statement of damages, can use the district court trial as a kind of discovery mechanism, watch what's going on, and then if the plaintiff gets a verdict for, $35, $55, whatever $1,000, just say,
wrong place.
Challenging it and go up to the Superior Court, and didn't have to raise it earlier because it was a subject matter jurisdiction problem.
Well, in light of the language in Section 19A, it says that any violation will not affect the jurisdiction of the court, and I think it goes on to say something like that if there's a mistake here, it will not result in any post-judgment relief. Why can't this whole thing be looked at in terms of the question of venue as opposed to jurisdiction?
Well, I think that's what the legislature wanted the scheme to be set up as a kind of venue question where, or any other procedural requirement, where if a party objects, he has to do it in a timely basis at that stage. So here, you have to make a timely objection to the case saying that it involves more than $25,000, and then, we have a problem here because it says no post-judgment review, but in the ordinary course, any violation of any procedural rule, whether it's a demand in a shareholder's derivative case, or whether it's a venue matter, or anything else, or some failure in a class action case, those matters can be raised subsequently. The problem here is there's also this provision limiting post-conviction review. Well, we would suggest, the problem goes back to the memorandum of Chief Justice Conley, who in essence reads this statute to say that the words requirement means no requirement, and who says in effect that the amount necessary in controversy isn't necessary. And so the way we think that this court could give meaning to all sections of this statute, the permissive language in may dismiss, and if you will, the mandatory language, proceed only if amount necessary and requirements, is to say that this is a requirement. The parties, if they want to assert an objection, must do it on a timely basis, and the only part that discretion applies to is if in a situation where there is no objection, but the court decides on its own that it's not the kind of case for whatever reasons are going on in a local venue, it doesn't want to hear the case. Now, I do suggest...
It doesn't want to hear the case because even though there's been no objection, it's clear to the judge that there's no reasonable likelihood of the recovery by the plaintiff.
No, my suggestion is that it may be a court which is very busy, and if...
No,
if
I
it-
understand, but the district court judge in a very busy court cannot decline to hear a case because it's complicated. It's a $10 case, as Justice Sperounes said, but it's complicated, and it's going to take 3 weeks to try. Can't just say, well, I'm not going to take that case. The district court can't just be shipping up all kinds of cases to the superior court.
Right, it could not dismiss a case in which the amount in controversy is
That's
less
what I
than
said.
$25,000.
There's no reasonable likelihood.
Yes. So, I mean, the hypothesis here is if the amount in controversy is more than $25,000, it's only then that discretion would fit in. And the further hypothesis is that most large damage cases are more complicated than small damage cases, which I think just as
So in essence, you want us to write in standards for cases that are over $25,000, is that right?
I'm sorry?
In essence, you want us to write in standards for cases that are over $25,000 to guide the judges in the exercise of their discretion. Is that?
No,
you don't want
that is not
standards.
our primary proposal.
Okay.
If neither party objects, then I mean, the court could write in standards for the district court keeping the case, even if it's more than $25,000, but need not do so.
I take it your position, Mr. Altman, at least with respect to this case, is if the defendant objects, you may need a hearing to find out whether the objection is valid or not, but if it appears that there's no reasonable likelihood that the recovery by the plaintiff will not exceed $25,000. In other words, if the defendant shows, look, this is going to be a $35,000 case, if the defendant objects to it staying in the district court, the judge has no discretion to keep it in the district court. That's point.
If the judge reaches a conclusion that there's a reasonable likelihood the damages will exceed
Correct.
$25,000, then he has no discretion.
If a party objects.
If the defendant objects.
If there's no objection from the parties, and there's a reasonable likelihood that the damages, I'm just asking whether what you're proffering, if there's no objection from the parties, any party, it could be a multi-party case, but there is a reasonable likelihood that the damages will exceed $25,000, then a district court judge has the discretion, but it's not required, the district court judge has a discretion to keep the case in the district court or to say that the case has to go to the superior court. Am I understanding you
Yes, that's our
correctly?
position, Your Honor.
But doesn't the statute require a motion by one of the parties to dismiss before the judge can take some action?
Absolutely. It requires a motion, a timely motion by the defendant to dismiss the case.
Well, it could be the plaintiff, too. It just says either party.
It would be, if it's a case greater than $25,000, then the plaintiff
Could have
option
second thoughts.
the plaintiff would file in the superior court, not in the district court.
So a judge can't do this on his own or her own. Can't do it sua sponte.
Well, if as in this case, the statement of damages said $250,000.
Statute seems to require a motion.
No, it doesn't
It
require...
I would ordinarily would require a motion. I guess it's not an issue in this case as to whether or not what would happen if no motion was made, whether the court could do it sua sponte or not. Justice Connolly in her memorandum takes the position that a judge could.
I think the
sua sponte.
statute would permit that. It just says if it appears to the court from the statement of damages, there's no reasonable likelihood. Presumably, the court can then ask for responses from the parties, have a hearing, and decide on its own. I don't see that the statute somehow requires a motion.
Mr. Altman, how do you deal with the second sentence of Chapter 218, Section 19, which said the actions, i.e. the actions of civil actions for money damages in the district court and the BMC, may proceed in the courts only if there's no reasonable likelihood that the recovery by the plaintiff will exceed $25,000.
Well, if the court is asking how do I construe that language, I construe that as mandatory language, consistent with the other language of it being a requirement. And the court before raised the question of venue. It may be that a certain court has venue. If no one objects to the venue of the court, then the case can proceed. And in this case, even though it should only proceed if the damage is at $25,000 or less, if the defendant isn't complaining and the court wants to keep it, then it may proceed.
Well, isn't the answer to the Chief Justice's question that you have to read that sentence in Section 19 so that it's consistent with the provisions in 19A subsection B? I mean, you have that one sentence says the actions may proceed only if there's no reasonable likelihood. But then it appears to give the judge discretion by using the word may in subsection B of 19A.
Yes,
And that's the problem.
Harmonizing.
That is the problem.
We have to harmonize them.
Yes,
The question is
we
which-
suggested the way
the
of dealing
question
with
which
it
way?
is as I indicated.
The question is which way?
And you've
Thank
made
you.
your suggestion.
Thank you, Mr. Altman.
Okay, thank you.
Mr. Pham?
Thank you. Chief Justice Marshall, members of the court. I'm Leo Pham, and I represent Mr. Farese in this matter. We agree that jurisdiction of the district court should include matters over $25,000, especially in that the statute specifically provides that it may be dismissed, that the jurisdiction is allowed to stay in district court, that in fact the judge has the discretion, and he's exercised that discretion, at least in this case. It was clear, the complaint was filed, the statement of damage did have in excess of $25,000. My brother at that time had filed the motion to dismiss. He had not at any point filed a responsive pleading to the complaint. And I think if you go through Justice Conley's explanation in her memorandum, it's clear that some responsive pleading should have been made. It should have been done by way of affirmative defense. That wasn't done in this case. Instead, he went directly to motion to dismiss. Motion to dismiss at that time was heard, non-evidentiary. It was an argument. And in part of that argument, the judge and the district court decided this is a contract action, whether it's $25,000, $1,000, or $250,000. This court, this district court, is capable of handling.
Yes, but that argument would make a nullity of this statute, because that would be true if in $1 million and $15 million suits, but that isn't what the statute says.
Well, it does say that in Section 19, in the first sentence, that actions for money damages originate in the district courts. That's where it originates. And in Section 19A, it says, as part of the discretion, the judge may dismiss it. The judge in the district court level would know better if his court is able to handle the case that's in front of him. In fact, he's made that decision. And I think from the bench, he's saying, this is a contract action. It's not a complex litigation. It doesn't matter whether it's $100,000 or $20,000. I'm capable of handling this case in this court.
But we're talking, there's a difference, it seems to me, if we're talking about where there's an objection filed by the opposing party, one of many opposing parties.
Well, the
Otherwise, essentially what you're doing, I'm not sure it's venue, but it's certainly jurisdictional in some way. If you, I mean, clearly the legislature is saying there is a monetary difference between civil actions for money damages between the district court and the superior court. If there's no objection from the parties, then there's an interesting question of statutory interpretation. There's no objection. Does the judge, if the judge determines that in fact this is a $35,000 or $35 million case, can the judge keep it in the district court? That's one scenario. But where there's an objection, why does the judge have any discretion to keep the case? In other words, you could have chosen to go in the Superior Court.
I could have also chosen to write 24,000 and allowed the judge in that court to make a determination whether it was more or
Well,
as
that's
part of
always
the
the case.
trial.
If there's an objection and then the defendant comes in and says, this isn't a $24,000 case, excuse me, I've got a, contract here that clearly provides for $72,000.
Well, I think the discretion works both ways, is what I mean, Your Honor. If-
Or he may hold your certification of $24,000 up to you at the time of judgment.
Well,
and
it's
say,
procedural. It's not jurisdictional. It's procedural. A jury of 6 in district court can award any amount, and it doesn't allow for an appeal if they award more than the $25,000.
No, of
That's
course
what
not.
we did by taking away or giving us the one-trial system. And in reading the memorandum in Chapter 252, which is set out, it's clear that this judge in the district court is given the discretion, and he's exercised that discretion. He's taken the case and the facts and whatever he's had as far as resources within his court and said, this case could be handled here. Not to my brother's liking, however, is no reason why that this judge couldn't make that determination or, in fact, use his discretion at that point.
Is there any legislative history on this?
I'm not aware of any specific legislative history. I understand that the memorandum does set out what was done in order to change over that 8-year period the one-trial system. And as part, in the end, changing the jurisdictional amounts to a procedural amount. I think that's a very important point in that they've worked with the jurisdictional amount, the remand and removal. To take it and make it a hard and fast rule is going to put us back to where we were several years ago.
Why?
Well, what's going to happen is now the judge, in any objection, would say, I have to remove it at that point because we've taken away his discretion, because if the defense or whoever raises the
But
objection...
you're only going to get one trial, no matter how you cut it, won't you?
Well, you still do, but I think in the light of judicial economy, we've already begun the matter. Now we've got to dismiss and refile, albeit maybe in the Superior Court at this point. Take it away from somebody who's already got something or some time vested in it, and let's start over again. So, in essence, it becomes a hard and fast line. If it's $25,000 and you think it's $25,000, you need to go to Superior Court, or if you file in the district court with objection, it's going to move. So at that point now, I think what that does is it sets it back. I think as part of this, taking away the discretion of the judge in the district court, in some respect, it doesn't mean district court is not as smart as Superior Court or the like. In fact, there are many good district court judges that could hear complex legal issues. It's their determination at that point whether or not they should actually hear it. And I think as part of that argument, in this particular case, this judge has said, I'm capable of handling this case. It should remain here. Now, it didn't provide specifically in the statute for an appeal from the judgment. I would think that would be after trial to say, because this judge kept this case, we should allow an appeal based on the jurisdictional amount. Again, we've made that jurisdictional amount change to procedural and allowed the district courts to take and make this case theirs if they decide to. Clearly, I think if the $25,000 line is drawn in the sand, now we become under more scrutiny as the cases are accepted into the district court. Do we require, although the statute doesn't require it now, do we require the clerks to investigate whether or not that statement of damage is accurate, whether or not on its face it's procedurally wrong, should it be moved at that point?
Well, the statute just says they have to they can't accept for filing unless there is a statement of damages. That's all the statute says.
That's all it says, and that's correct. But I think in this situation, if we were to make this procedural amount a hard and fast $25,000 upon objection, I think we also have to put now the clerks under scrutiny to say they've seen it.
Why? Because if it's on objection, the clerk doesn't have to go and ask to the defendant. The clerk, takes it in. You have to have a statement of damages. It says $35,000. The case is docketed, and there's a motion filed. to
Well,
dismiss.
I would just suggest, Your Honor, that at that point, it may be, at that time, it's got to be made aware to whoever it is, plaintiff's counsel, whoever's making the filing, that this is $25,010. Did you consider filing in Superior Court? Do we just accept everything that comes in and let the parties deal with it? Yes, we do accept it. Is that?
Yeah.
I would suggest that at some point, we would also have the judge in the district court, would they have the right, sua sponte, to move the case if they look at it and feel as though it's more than $25,000, even without objection? Does that create another issue? I don't know if it does.
Yes, no, because that, it seems to me, that's the one part of the statute that may be clear, which is, it doesn't say, it simply says, after receiving written responses from the parties, what that suggests is that that's not on the motion of a defendant, that's the judge asking the parties and having a hearing, if requested by any party. So I think that's just the...
And then the next clause.
And then the next one, may dismiss, but that suggests may keep it. It strikes me that what that's dealing with is where there's no objection, but the judge wants to find out, was this a typographical error? This is a $25,000 case, but in fact, whoever, filled out the form, typed in or put in the 3 by mistake, whatever it is.
But I think we go back to the same premise under 19A, that the district court judge may dismiss. If he doesn't dismiss and he decides to keep it, then at that point, I think we've issued whatever objection we've had, and the judge has had his opportunity to hear whatever facts from both parties and has made an informed decision. To move it at that point even further, based on what we have here, it goes beyond taking away the discretion of that district court judge. That's where I think this case, specifically under 19A, is clear, that the judge in the district court has done exactly what was asked of him. He's made a decision. It doesn't call for, it should not call for, appeal of his decision on whether or not he should keep the case, and yet we are here under this writ. So I think Section 19, in the first sentence, allows the district courts to have jurisdiction over civil money damages.
In any amount.
In any amount, because of the first sentence, leaving Section 19A to clarify that it may accept claims over $25,000.
Thank you, Mr. Farmer.
Thank you.